Good afternoon, everybody. A full room as usual, which is nice to see. I'm going to just talk about 4 topics quite shortly, and then we'll ask you if you have any questions afterwards. The first is going to be the qualities that you will need to be a barrister, a question I often get asked on the stand. How to get pupillage, the $1 million question, so I'll give you some idea about that too. Public funding, the elephant in the room. I'll tell you something, or my views at least, on that. And the last one, my son's here today, he told me to not to forget to tell you how enjoyable the job is, which is a very good point actually, so I'm going to talk about how enjoyable it is. So first of all, qualities of being a criminal barrister, what do you need to be? Some of you in this room may consider yourselves to be naturally gifted advocates and the bee's knees. Others of you may think, well, I feel slightly underconfident, I'm not quite sure I'm from the right background, and other concerns. The good news for the second group is that one of the most important qualities, if not the most important quality at the criminal bar, is hard work. So you need some natural ability, that's fine. When I was sitting where you were, and in the year or two afterwards, I would see the person that believed himself or herself to just be the natural born advocate. They were brilliant, they were the finished article, the bee's knees. And then 3 or 4 years into my career, I started to see them less often. And then 5 or 6 years into my career, I didn't see them anymore at all, because they stayed exactly where they were from the very beginning, because they were already in their minds the finished article. I do advocacy training at 2 Bedford Row. At the end of every 2 or 3 hour session of advocacy that we have, which we have on a 2 or 3 week basis, the final line is always, so as usual, it comes down to hard work. If you prepare a case very, very well, and you know it back to front, and you've thought of all of the arguments that are possible, standing up to deliver those arguments is easy. And it's that old phrase, I suppose, you train hard and you fight easy. It's very similar in advocacy. If you haven't read your papers and you stand up and the judge says to you, well, Mr. Vullo, what's your case on this? The advocacy is going to be poor if you don't know what the answer is. If you've prepared it fully and you know exactly what you're talking about, the level of advocacy is going to be high, because you can just tell the judge in plain and simple English what your point is. So hard work is the first thing that you will need, and everybody in the room can deliver that, so nobody is at a disadvantage in respect of that. You do need, obviously, the ability to stand up and talk either in front of a group of people like you or a group of other people, sometimes a jury. You can learn those skills, you can learn to relax, you can learn to pace yourselves, and you will do that through your career. But if you are somebody that doesn't like standing up and talking, then you're probably in the wrong room, and you should go and do like tax law or something. Fascinating area of law. You know, of course, that if you go to a dinner party and you're a tax lawyer, everybody will want to ask you what you did at work that day. That's not true, that's a joke, you can laugh about that. But, how to get pupillage. In reality, I think it's very difficult. I look at hundreds of these forms that you're compelled to fill out. Why do you want to be a barrister? Why do you want to apply to 2 Bedford Row? Why do you want to be a criminal barrister? And all very difficult questions for you to answer, both honestly and differently from the hundreds of people around you. In fairness, if you get rejections or do not receive interviews from the written application, I honestly wouldn't be too down about that, because I'm quite sure and will readily accept that when I'm looking at forms, everyone looks much of a muchness on a form. You will all be well educated, you have all saved pandas and China and done all of those things. And it's very difficult, and I'd be quite willing to accept here and now that I would almost always accept that I may make mistakes on the forms. I may be putting people through to interview that shouldn't get an interview, and be rejecting people who might be brilliant if they walk through our door. Because for us, we're not experts. It is difficult. You put things that maybe make you stand out slightly on the form if you can. Do many pupillages in the chambers that you're interested in. It's very difficult to answer the question, why can you tell us from the age of 2 was 2 Bedford Row the only chambers for you, if you've never done a mini pupillage with us. And if it shows, check your form very carefully before submitting it. There's always somebody every year. I'm at 2 Bedford Road telling me why 6 kBW is the only set for them. And that's very difficult to extricate yourself from in an interview situation. So check your form. What I can probably give you some more constructive advice on is once you've received an interview, certainly at 2 Bedford Road, I'm sure in essence it's the same in every criminal set, there is only one thing that I'm interested in when somebody walks into a room at 2 Bedford Road for an interview, and that's advocacy, the ability to stand up and speak. That's it. We have no concerns whatsoever as to your background, what university you went to, whether you even went to university. Both of us, strangely, just realised talking to each other, we both went to polytechnics, and we're standing here and we're doing okay. So I, on the stand, often get asked by people, do you need to have gone to Oxford and Cambridge? There's nothing wrong with going to Oxford and Cambridge. You get a great education from there. The point is, it doesn't matter whether you did or whether you didn't, because I honestly tell people every year we have our pupils on the stand, and I don't know what universities they've gone to. I don't have that knowledge in my head. I genuinely don't know, and I often ask them on the stand to tell people what university did you go to, and we usually have a fairly good mix. Just walk into a room with some poise, stand behind the lectern or the cardboard boxes we often give you, and deliver a decent piece of advocacy. That's it. Sounds very easy. It's just talking. But as soon as you ask somebody to talk in a formal situation, it seems to get incredibly difficult. A trick might be, if I'm ever in front of a High Court judge or in the Court of Appeal, certainly when I was younger, I used to picture the High Court judge having Sunday breakfast with his grandchildren in a jumper and some cords. I know, it's weird, isn't it? But if you just picture somebody like that, they become less intimidating, and you can just talk to them. And don't use long words. Don't try to sound like a lawyer. There's nothing worse than somebody trying to sound like a lawyer. But when we're in court, the finest advocates never say anything that's difficult. They never say a word that you wouldn't readily understand, or my 8-year-old son would instantly understand it. Only people trying to sound like advocates use long words, Latin, and other things. It's totally unnecessary. It is just talking to someone with nerves, and we appreciate you have nerves, but that's it. Public funding, it's much more difficult now. I've been asked, actually, just very recently, to sit on the social mobility unit at the Bar Council, and I went to the first meeting, and the first meeting has identified the problem. I'm not sure, to be honest, what the solution actually is ever going to be, because people from more privileged backgrounds tend to have been in a situation where they walk into rooms and deliver talks to people more often than those of us that didn't have that type of start. Now, that's not their fault, it's nobody's fault, it's just the way that it is. So if you do come from any type of background where you feel you haven't had a great deal of experience walking into a room and talking to anyone, do it in front of your mates. Now, there are two reasons for that. One, they will find it hilarious, so they're going to have a good day out. But if you can walk into a room and command the attention of your friends, who will laugh at you, obviously, for the first sort of 30 seconds or so, but if you can actually command your audience with friends, talking about the new criminal justice bill for 3 minutes, concisely and in a way that they can understand, that's good practice, because that's advocacy. Everyone has got some mates, and so everyone can do that, but you must train yourself to speak in front of people. It's no good thinking about it in your head. It's like if you're going to run 100 metres, you don't sit there thinking, yeah, I'm going to run really fast. You have to train to do it, and advocacy is about standing up and talking. So do it as much as you can in whatever situation you can do before walking into us to do the interview. But I was talking about public funding. Your fees have not been cut at all. I'm not aware of any of you having received a legal aid fee so far. Has anyone received a legal aid fee? Is anyone a qualified barrister in practice? No. So you've received no cut to your income. We have, potentially, but you haven't. So all that really means for you is that when you come into the profession, you may not earn as much money as you may have done a few years ago. And so you will cut your cloth and you will live your life according to the income that this profession now offers. In terms of the practical effects, we appreciate it is more difficult now. Certainly when we did it, it was probably a struggle to go through the process of pupillage. But once we actually got there and started to work, there would be an income, maybe modest, but there would still be an income that could get us by in the first couple of years. That's maybe not necessarily true across the criminal bar now. And what people are going to have to do, the determined ones amongst you, you're going to have to do slightly different things. For example, going in-house for a couple of years, learning some skills there. There's no rush in this business to get into the profession when you're 22 or 23. How old were you when you came in? Did you come straight through?
31.
31. I was 29. And I remember, probably you as well, Di, having this terrible feeling that I'm 29 years old. That's old, not now, but it felt old at the time. Thinking I've missed the boat, all these people are going to be miles ahead of me. I went to a mixed dining where you have to sit with the masters and got to sit on the top table ridiculously. But anyway, I did, next to a lovely man called Master Sherrod, and he said to me a great piece of advice which I pass on all the time because it's true. That people that come to this profession a few years after the natural age that you could possibly come at it you catch up because of your age and your experience. So don't rush. There is no rush. And he was absolutely right. I would say after 10 years call, I was doing work with people of my age that came through 5 years before me. It really didn't make any difference. And I'm on the Silks list this year. I'm 17 years call, so by and large I have absolutely caught up. I think for myself personally, I've had the advantage of coming to it slightly older, a bit more mature, a bit more willing to put up with the hassle and the difficulties of the job. So I know you're all young, well most of you are young, some of you are not so young, I'm not going to pick you out. But the people that think that, well, I haven't come straight through to do this, don't think I've missed the boat, you haven't. 30, I think, is a great age to come into this profession. So you've got a few years, or most of you will have a few years. If you don't get pupillage first time round, go and do something in-house, get some other experience, get a little bit of money in the bank, and then come back as it second time round, because there isn't this crushing rush to get into the profession. Last thing to say, which Harry's told me to remind you of, how enjoyable this job is. And I must say that with all the difficulties of it, I, in my career, have represented the Glasgow bomber, one of the 21st July bombers, the Saudi prince that killed somebody in a hotel room, his manservant. I've just finished the Dave Lee Travis case. I'm doing his next one to come. It's a fantastic job to do. I cannot think of anything I'd prefer to do. And I honestly can say that if I were in your shoes now, lots of people will be putting you off. Lots of people will be telling you, go and become a corporate lawyer, do something else, don't do crime. It's a fantastic career. It's so interesting. As I say, you can either be the person at the dinner table when somebody turns to you and says, well, what did you do today? So, well, I dealt with a border dispute. Somebody's got a hedge 6 inches too far to the right. Fine. What did you do, Di? Oh, I'm in the middle of a murder trial at the Old Bailey. Okay, fine. I'm talking to Di, as you all would. Nobody makes movies about hedges. Okay? It's a really, really enjoyable job. Don't be put off. It is more difficult than it used to be. It shouldn't be, but that's the funding position. But just go for it, because it is a fantastic career, isn't it?
Yeah.
It is. And I'm going to hand over to Di.
Hello, everybody. Round of applause straight away. Very good. Right, everybody. First of all, I'm sitting down, having spent several hours carrying a placard yesterday, and in fact just noticing a bruise on my hand. Then I thought I would save my legs and talk to you this way. So I hope the cameraman's all right with that. I can absolutely endorse everything that Stephen's just said to you, and there are a few things to add. But I will add some. First of all, let me give you a kind of 1 minute on who I am and what I do. As Stephen has just established, I came to the bar at the ripe old age of 31, and I'm now 16 years call, so you can do your sums and just say, don't you look young for your age, please.
36.
And I am a barrister at 2 Garden Court and Garden Court Chambers, in fact, and I practice in criminal defence. That's all I do. I don't prosecute, and I don't at the moment do any other area of law particularly, although I have done and will do in the future. My job is defending people. And I defend at all ranges, all ages, all kinds of offence, from assaults to terrorism to drugs to fraud, and at all levels. So, like Stephen, I have a wide-ranging practice within the criminal law. And having spoken to you about coming into this job or wanting to come into this job, I think what I would add to what Stephen has been saying to you is this. Manage expectations. It's a very helpful thing when you are thinking of coming into this trade. For instance, managing expectations of pupillage, do your research. Now, when I've been on pupillage committees in the past, and I have many times, for instance, I've been surprised sometimes when I've seen an application from someone who wants to do pupillage in my chambers and wants to prosecute. And I've only ever been in chambers that do defence work. The thing is, for you guys, you're filling in lots of forms, you're casting your net across the waters widely. You have to do that to be able to get something to bite, but you do have to be very careful to know where you're applying, which chambers you're applying to, what their specialism is, and in that specialism, what kind of level of work they do. There are many defence sets, but not all of them do the kind of level of work that Stephen's set and my set do, for instance. Some of them have specialist fraud areas, for instance, and that's really what they do. If you go to those sets and say, what I'd like to do is for instance, work involving vulnerable witnesses like those with mental health or vulnerability problems, they may not be the right set for you to apply to, because that may not be their client group, for instance. So you have to be careful to manage your expectations of what you will find at which chambers. Another thing is this: it's good to know what the job is on a day-to-day level. The best way of doing that, as Stephen has said, is to go and do mini pupillages. Now, our sets have mini pupils, not all sets do. Some sets don't necessarily encourage that, most do. But if you can't get a mini pupillage somewhere, because we have mini pupils, but we have them whilst we're working. There aren't special people who look after mini pupils other than our wonderful administrative staff. You come with us to work, and there will be times when we aren't taking pupils, for instance, mini pupils. Go to court. Criminal courts, apart from the youth court, are public buildings. Go and sit in them. The Old Bailey looks like it's very forbidding. It's not very easy to get into because the public galleries are around the side, etc., but you can go in. And in fact, they're very helpful at the Old Bailey because they'll always tell you what's going on in each court. Oh, that's boring there, it's legal argument. Yeah, this will be good in this court. But also, go to magistrates' courts. Something that many pupils or would-be barristers don't realise, perhaps, and this is going back to managing expectations, is that, like all jobs, when you train to be a hairdresser, you sweep up the hair. When you train to be a doctor, you go and watch someone having a wart removed or something like that. It's not all brain surgery from the get-go. When you're a barrister, you start in the magistrates' court, you start with fairly straightforward cases, perhaps to some people unglamorous cases, but of course to the person who's standing there accused of whatever it is they're accused of, this is a life-changing situation. And so it's very important for you to go and see it, because those are the kinds of venues that you will be operating in to start off with. And so you can do that in your own time. And if you're coming to the job late, like Stephen and I did, if you're doing it by design rather than by accident, work into your career plan, building on your experience. Work into your career plan, even now perhaps, doing advocacy work in other areas. Some of you will be doing CAB work, or you will be doing student legal advice, etc., etc. Advocating for people is advocacy. Even if it's sitting down like I'm doing at a tribunal and speaking on behalf of someone who is in the belly of the beast and can't speak for themselves, even if it's going to a school to talk to other pupils about what it's like to be at university. It's all advocacy. It's all talking, and it's all there to make you more confident in standing up and getting your message across. So I can really recommend building that side of things, because, like Stephen, the fact is your qualifications, how you are on paper in your applications, once you're in, all of that becomes much less relevant. There are many of us, and I include myself in this, that quite frankly I would not be able to be a barrister now with the A-levels that I've got. But I spent a few years as a teacher beforehand, several years as a teacher beforehand, and came in that way. So I already had a career under my belt that I look back on fondly with nice summer holidays, etc., which I don't get as a barrister. So work into it. Some kind of advocacy training, advocacy planning, watching it happen, etc., etc. And finally, I think I'm near to finally, on the managing expectations front, criminal law looks terribly glamorous. We wear silly outfits in the Crown Court, and we swan about a lot, and you know, all of that is absolutely true. I'd like to say it's not, but it is.
It's true.
And it's terribly good fun as well. I completely agree with Harry's excellent point. It's terribly good fun being a barrister, but particularly when you defend people and prosecute people, i.e. criminal law, which you're all interested in, you see things that aren't pleasant, you hear things that aren't pleasant, things happen in cases that are traumatic. You deal with people on either side of the fence that are extremely traumatized by the things that they have experienced. You see people who are really in the most difficult and vulnerable groups in society. And for all you may be drafting a very interesting and extremely important and sometimes novel legal argument, an hour later or the day later, you might be in a cell with someone who is withdrawing from multiple drug addiction. You might be speaking to someone who has been wrongly accused of killing somebody. You might have to look through evidence that contains images that you would not wish anyone to look at, but you have to look at because it's your job to do so. And all of that is very much the less glamorous side of the job, but it's very, very much part of your job. And so as much as advocacy is important, having a kind of strong sense of yourself and a belief in yourself and an ability, in a sense, to throw up a sort of mental shield and keep yourself at a distance from the things you're dealing with is a good thing too. Doctors, by and large, don't run out of operating theatres going, oh, there's too much blood. And so likewise, criminal barristers have to steel themselves against running away from a set of images or breaking down when a witness is breaking down in giving evidence. I can tell you many times I've been in court and I've had sitting behind me perhaps the parents of a murdered child, sitting right behind me closer than you are. And you have to be mindful of that. It's not the sexy side of the job, but it's very much part of it. And going right back to what I was saying at the beginning, perhaps the best way of seeing that is to go to court and watch it, because it will give you a much better clue. It's defending people particularly, but also prosecuting people, is a very multi-skilled job. Advocacy is right at the top. Speaking, because that's what you do. You speak for people and you question evidence. That's the really the heart of the job, is questioning evidence on either side. But also people skills, speaking to people with respect, no matter what they're accused of doing, treating people in a humane way, no matter what they're accused of doing. Whether you believe their account or not is as irrelevant as anything could be. Your belief in a case is irrelevant because you're there to create the case, present the case, and hopefully successfully present the case, whatever it might be, whatever side you're on. And so there's also the skill of keeping your own moral views, your own opinions to one side. So when you go into this, as you already are, you go in, I hope, with confidence, self-belief, but with a very realistic and real sense of expectation, not only about the career side of things, as in whether you get into it successfully or not, but also once you're there, what will it be? I think that's all I'm going to say.